staying tuned. It's you and Valor right here on OGTV. Today we will be looking at a critical issue that has been facing millions of lives in Nigeria. This is talking about the discovery of petroleum in Nigeria, and somehow this topic feels like it's a double-edged sword. On one hand, it brings economic development. On the other hand, it has caused a lot of environmental issues, placing the lives of many Nigerians into health problems and also community issues. It has also led to displacement of some of these communities and human rights violation, particularly the rights of the indigenous communities. Well, joining us on the program today is Barrister Isong Asuko, who is a lawyer residing in Port Harcourt. Thank you so much for joining us. Can you hear me? Barrister, can you hear me? Okay, so I think we're having, can you hear me? Please say something. I think you're muted, Barrister. We're looking
I can hear you.
All right.
Can you hear me?
Yes, I can hear you now. Well, we're taking a close look at indigenous communities, petroleum and development, and the stand of the law. Well, first of all, let's start the conversation with the nature of things with these indigenous communities in Port Harcourt. Because when you talk about petroleum, Port Harcourt is that one state one will definitely point at. So what's the nature of things in that place?
Okay, first and foremost, we must lay an historical foundation of how petroleum came about in Nigeria. Looking at the discovery of oil at Ulube, Bayelsa State, sometime in 1926. And then the need for ownership of petroleum resources as was spelled out by the United Nations Declaration on Permanent Sovereignty over Natural Resources Declaration of 1962, which brought about remarkable change in the ownership structure generally in the world. And then the subsequent enactment of the Petroleum Act of 1969, and then the establishment of the Nigerian National Oil Corporation that was subsequently changed to the Nigerian National Petroleum Corporation in 1977 by virtue of the NNPC Act of 1977. And we've had this trajectory of consistent development in our petroleum industry. But it is hard to state that the Petroleum Industry Act of 2021, after careful perusal of the Petroleum Act of 1969, it was discovered that there was a need for a reform, particularly with those communities here referred to as indigenous communities. And then there was a need to also improve the livelihood of these communities. And that's why we have the Host Community Development Trust. The Host Community Development Trust will now have the trustees and a particular percentage given to this Host Community Trust by the settlers. The settlers, by settlers, are being the multinational oil companies who are involved in exploration and production of petroleum resources. And then through the licenses given to them, it is now an obligation under the Petroleum Industry Act by way of Host Community obligation to ensure that they keep to the mandate for which they were given by way of the licenses and leases given to these multinational oil companies, hereinafter referred to as SEMS. I hope you can hear me.
Yes, I can. Let's go back to the trust you made mention of. It's not really clear. So you're saying there's a provision by the law to compensate these indigenous people for whatever development that comes to their society or community, and probably the damages it must have caused them.
Yes, if I understood the question clearly, we've had a remarkable paradigm shift, we say, with regards to the compensation regime for host communities under the PIA 2021. Let me explicitly state that by virtue of Section 101 of the and then Section 102 of the PIA and Section 103 of the Petroleum Industry Act 2021. We have called environmental remediation compensation regime. That is the environmental degradation occasioned by activities of multinational oil companies. There is now a provision for environmental remediation fund under Section 103 of the Petroleum Industry Act. That is, the law foresees that there is possibility of environmental discrimination by way of activities of these multinational oil companies. And there is a particular fund specifically created to remedy some of these defoliation by way of degradation occasioned by these activities of these oil companies. And if you want to discuss by way of historical establishment of foundation, you tend to see that communities like Bonny Island, where we have the Nigerian Liquefied Petroleum Industry, the NLNG, and then we have the element Chemical, that also has the proposed, the abandoned water refinery for many years now, and the consistent proclamation by the Nigerian government to refurbish that refinery and make it functional to bring about energy security. These are some of the major communities. You see Ogoni too has been one of those communities in River State that has been very useful in terms of oil extraction, and the end product thereof being used in this country. Considering the fact that petroleum contributes 95% of foreign earnings and more or less a known economy for Nigeria as a country.
All right.
But the major challenge you have,
we'll talk about the challenges, but I think it's clearer now that in place of some of this environmental degradation that these activities could bring, there are compensations stipulated by the law for these communities. What happens when some of these compensations don't get to the people who are affected by this economic development?
And that has remained a serious contentious issue over the years in the relationship between the settlers, that's multinational companies, and the host community. This is a funny issue that has remained over the years. And then we tend to see that you can't commensurate, no matter the amount of compensation, to the damage occasioned by activities of these oil companies. So we now look at the issue of the adequacy otherwise of this compensation question. And then we tend to see that how adequate has this compensation been, and has it gotten to the major victims affected by these activities of these multinational companies. That remains an issue that will take a long time to be resolved. It's to see that some of these communities have representatives by way of chiefs, village heads who are representative of these communities. And we also tend to see that most times when this compensation is gotten on behalf of these communities, it doesn't get to these communities, thereby encouraging vandalization. And that is why we have consistent vandalization of pipelines by, will I say, youth of these communities. And that is PIA, in order to solve this problem, has a provision for sabotage. And this sabotage has been specifically linked consistently to host community, which personally experts like us in the industry kick against. Because some of these plants could be blown out due to aging by virtue of long stay without consistent revisitation by these multinational oil companies. So these are some of the challenges which has remained a thorny issue in the industry over the years.
All right, thank you so much. Time is really not by our side, but I just want you to touch a little bit on the rights of these communities. Yes, there are compensations open to them according to the law that are supposed to be allocated to these people. And there are times where some of these allocations do not get to these people, maybe for one reason or the other. And sometimes it leads to vandalization, like you said, because some of these people feel they are left out. Are there rights that the law provides for these people, aside the compensation now, you know, especially when it doesn't get to them? Are there rights that protects them, as per se?
Yes, of course. Where you know that the law has carefully provided some of these rights. For instance, we have the Land Use Act of 1978. One of those basic rights of those communities or indigenous communities is land ownership. Land ownership is key. And then most of these lands were inherited lands by virtue of inheritance, family lands, family properties. And how do we ensure that these lands are not compulsorily acquired or oil companies utilizing it for extraction of oil and not adequately compensating these communities? There is what we call surface rights. The surface rights ensure that you know that by virtue of Section 1 of the Petroleum Industry Act and by virtue of Section 43 and 44 of the Constitution of Federal Republic of Nigeria, going by the case of Federal Republic of Nigeria and AG Federation and AG Abia State and 35 others, the Supreme Court had established that natural resources belong to the federal government. So as such, whatever compensation is being paid to indigenous communities or host community is only surface rights. And this surface right is by virtue of extraction of this natural resource called oil or perhaps gas. So I think the history of land ownership is the major right enjoyed by indigenous communities. Then you also have customary rights. The customary right is the right of these communities to ensure that established traditions and customs, established objects, long-cherished traditions are not venerated by activities of multinational companies. Hence, by virtue of Section 1, there is a provision for damage. Compensation for damage to
venerated objects. We're wrapping up now. Time is really not by our side.
It's okay, no problem, that's fine.
Yes. We will definitely have to bring you back on the program because this is a topic, it's an issue that is affecting lots of Nigerians. And the more we know about the law, the better for us as a country. Thank you so much for coming on the program today. And we trust that our viewers have been able to gather one or two things for themselves. This is You on the Law, where we bring you legal practitioners and we weigh in societal matters and the law. My name is Miriam Usman. I'll see you next week. Bye for now.
Thank you so much. Thank you.